Hi there, John Cattie, managing partner of the law firm of Cattie Gonzalez. Hope you're well, and I'm here to give you your November 2025 Camp Lejeune litigation update. So as we move into late 2025, the litigation under the Camp Lejeune Justice Act remains active and evolving on multiple fronts. While resolution for many claimants still lies ahead, there's some important developments and timelines to keep in view for both individual claimants out there as well as attorneys who represent claimants in the Camp Lejeune litigation. So we know that the filing window for all Camp Lejeune Justice Act administrative claims with the Department of the Navy has closed. It's been closed since August of 2024. At this point, at latest report, the Department of the Navy has reported approximately 409,910 unique deduplicated administrative claims have been filed, understanding that some claims filed were duplicative of previous claims. Out of those 409,000 claims, approximately 167,000 contained at least one supporting document, and about 64,000 of those alleged an injury type that might be considered under the elective option, the EO. Earlier, if you go to CampLegeuneLienResolution.com, you'll see that we have written extensively about the EO and updates to the EO that have been made by the federal government over the course of the litigation. So at this point, we've got all of those administrative claims. There are approximately 3,700 lawsuits filed in the Eastern District of North Carolina, complaints filed with the federal courts that are active and pending and split up amongst the federal judges within the Eastern District. To date, the only claims that have been resolved are those involving EO offers accepted by claimants. Further, as part of this process developed and encouraged by the settlement masters of the Camp Lejeune litigation, only 3 of the 25 cases that were mediated earlier this year were resolved. There have been no trials so far, and to my knowledge, no other offers to settle a pending Camp Lejeune Justice Act claim outside of those resolved either under the EO or those 3 cases that were settled via mediation earlier this year. So the litigation's proceeding forward through 3 broad phases or tracks, right? Phase 1 involves water contamination and exposure. Phase 2 involves general causation, whether the exposure to the contaminants in the water can cause certain diseases. And then phase 3 is specific causation, whether a given claimant's illness or condition was caused, or at least as likely as not caused, by the contaminated water at Camp Lejeune. Expert discovery in those phases is ongoing and substantially underway at this point, and the qualification of certain experts is remaining an issue impeding resolution of these claims. So, importantly, one of the next major phases of this litigation are the so-called Track 1 bellwether trials, which are going to test a certain number of representative claims, I think it's 45 overall, involving serious diseases such as bladder cancer, kidney cancer, non-Hodgkin's lymphoma, leukemia, and Parkinson's disease. Okay, originally those bellwether trials were anticipated to happen in 2025, but those have now been pushed and expected to begin in 2026. At the same time, I said there's lots of moving parts to this, right? Another moving part to this litigation was the appointment of settlement masters to oversee the negotiation and framework of a global resolution process, okay? So here's the update with respect to global settlement framework and the elective option that's out there. On March 21st of this year and June 16th, the court appointed Thomas Pirelli of Jenner & Block as well as Christopher Opperson of DLA Piper to be the settlement masters jointly for the Camp Lejeune litigation. To date, those settlement masters have filed 3 status reports regarding the settlement process to date. These reports, if you look at them, address efforts undertaken by the settlement masters and the parties, the U.S. Department of Justice, and the plaintiffs' leadership group, all together, all the parties, to resolve matters before the court and in the Navy's administrative forum. Okay? The stated goal of the settlement masters is to have a global resolution of the Camp Lejeune litigation in place by the end of 2025. Now, even for the best of us, that seems optimistic at this point. To achieve that goal, the settlement masters have created a three-step path to meet that time frame. Number one, bellwether mediations that would help the parties to value specific types of cases and to identify the variables that might impact settlement values in any matrix that they would develop. 2, a questionnaire process that would provide detailed information about the sample of cases that the parties could extrapolate to the universe, the population of claimants as a whole, which, again, more than 4,000 claims included in this administrative process. And then number 3, the development of a global settlement framework, including negotiation of the financial terms of a settlement, as well as other necessary terms that would need to be accounted for within this global process. So today, I briefly mentioned it, there's been 25 bellwether mediations earlier this year. Of those 25 mediations, 3 cases were resolved. According to the settlement masters, the parties and the settlement masters gained important information on how the parties evaluated the cases that may ultimately facilitate development of a settlement matrix, including relevant factors for such a matrix. The settlement masters intend to continue to work with the parties to resolve additional bellwether cases. On September 24th of 2025, the parties and the settlement masters finalized the claimant questionnaire, which, subject to negotiation between the parties since February of 2023. So this questionnaire going out to approximately 25,000 claimants. They're being asked to answer a lot of detailed questions that's going to end up providing additional information about different characteristics of the entire claimant population, the universe of claims here, 409,000 or so. Claimants have 60 days to complete that questionnaire. Okay? While this questionnaire process is proceeding, the settlement masters are continuing to work with the parties to negotiate provisions that will be necessary for this broad settlement of all claims. The settlement masters have met individually and separately with each of the parties on October 3rd to discuss next steps, and now we're scheduling a series of meetings going forward in order to facilitate and drive this towards a global resolution, which the goal stated, end of 2025, okay? Understanding that even though that might be in place in terms of a formalized settlement process, it doesn't mean full implementation, claims resolution, and disbursement of proceeds. We are a ways away from all of that happening. Now, throughout all of this, we've got it layered with the elective option, the EO that the federal government is offering to certain claimants who, with certain types of criteria being met, it's a quick pathway to resolve a claim. We've written extensively about this EO process out at Camp Lejeune, lienresolution.com. I encourage you to go look at the blog posts that were posted there about that process. It is, for those who qualify for this and receive an EO offer, it's a quicker way to receive settlement money. However, it probably is an offer of less money than what might be available down the road, and it doesn't fully relieve you of any sort of lien repayment obligations. More on that in a minute. So, where we are now, what's it mean for claimants and for counsel? Well, for claimants in the litigation, if you filed an administrative claim timely with the Department of the Navy, meaning before that August 2024 deadline, and you're waiting to hear news, know that the process is ongoing, whether you've received current news or not. Okay, things are moving, the process is in motion, but there are going to be substantial delays. We are a long way away from you having money in your pocket as a result of this litigation. Okay, payment on your case is not going to happen anytime soon. All right, if you're eligible for an EO offer and you've received that, you need to evaluate that EO offer carefully. Okay, accepting an EO offer, it will mean quicker payment to you, but it also may limit your potential upside compared to the full litigation pathway if you were to decline the EO and wait for a global resolution process to be established. All right, so you need to determine what's more important to you. Is it more important to have that money now, which might be lower than what you may be able to get down the road, or are you able to wait for that global resolution process to play out and get what most likely would be more money than what the EO offer is that you have in front of you. There's things to weigh and balance there. Okay. Also understand that that EO offer might be subject to lien repayment. Okay. So while the terms of the EO do include a waiver of any repayment for Medicare or VA benefits you may have received to date, there's other potential lien holders that are out there that might have their hand out looking for some money from your EO settlement. Medicaid specifically, TRICARE specifically, private and ERISA lien holders. Okay, there's other lien holders who might have their hand out looking for money from your settlement through the EO process. Okay, so before you can accept an EO offer, you need to understand exactly what that potential lien repayment obligation looks like. Okay, if you are represented by a lawyer, talk to your lawyer about that issue and instruct your lawyer to seek more assistance from Cattie Gonzalez to address your lien questions. If you're not represented by counsel in this matter, feel free to reach out. Go to info@cattielaw.com for more information. Now, if you have filed a claim timely and you have not yet filed suit in the Eastern District, if you haven't filed a complaint, okay, you need to assume that you're going to wait a while on payment. We haven't even gotten to the first bellwether trials yet. They're now expected to happen in 2026. All right, and any sort of global settlement process that's going to happen that involves you is going to be negotiated and implemented after those trials, most likely. So while the settlement masters desire a global process to be in place by the end of 2025, at least for me, that feels overly optimistic at this point, and I certainly would expect that deadline to come and go without a global resolution process in place. Okay? Final tip for claimants here. Stay vigilant with respect to your documentation. Okay? If you can gather as much documentation as you can, it's going to be helpful to the final resolution of your claim. Okay? There's a special emphasis that's being placed on supporting records like service records, medical records, residence or work records at the camp. Okay? It's going to be those with better documentation who are going to be best positioned when a future global settlement is achieved. Now, for attorneys who represent claimants in the litigation, here's what you ought to be keeping your eye on. First and foremost, you need to monitor the joint status reports that are filed on the Plaintiff Leadership Group's website, www.camplejeunecourtinfo.com. It's your best source of information about the litigation, okay? Go there to check out upcoming deadlines, expert disclosures, docket entries, settlement framework updates, and other critical updates to the litigation so that you can keep your clients informed about status, okay? Review your clients' exposure windows, their residence and employment at the camp. Tarawa Terrace, Hadnot Point, Holcomb Boulevard, right? And ensure that those records are all in order. Again, same advice as for the claimants out there. It's the cases with the best documentation, the best record that are likely going to be at or near the front of the line when it comes to settlement disbursements, okay? Now, if you have clients who are eligible for the EO, weigh the benefits of a quicker resolution process versus the potential upside via full litigation and eventually a global resolution process being in place, all right? Be aware of the deadlines that come with the EO offer once they're tendered because those are time sensitive. But be prepared for your clients who may be EO eligible to be able to act and give them good advice, all right? And how can you provide advice to your client about whether they should accept an EO offer or not if you can't even tell them what they can expect to net from that offer once liens are applied and paid back? Just because you're accepting an EO offer and you get a waiver of Medicare and VA repayment obligations doesn't mean that liens are fully addressed, right? There's still Medicaid, there's private and ERISA, there's TRICARE. You know, they're all potential lien holders looking to collect, right? I can share from experience, specifically when it comes to Medicare Advantage plans, Part C and Part D plans, that are represented by subrogation agents like Rawlings. They're asserting rights of recovery under statutes outside of Camp Lejeune Justice Act. They're saying that they have lien rights, not just offset rights. Okay, so you need to be aware and to be addressing these issues and be prepared to advise your client about what this is going to look like. Bottom line here for the attorneys, you must address potential lien obligations before you can ethically advise your client whether to accept the EO offer or not, okay? Couple final points. Understand that any global settlement matrix, whether it's agreed to by the end of this year or beyond, it's going to take time to implement, right? So even after agreement might be reached by the parties, structured payouts, allocations, individual claim processing is going to take months, if not years for some, all right? As counsel, you need to manage your client's expectations accordingly, all right? Make sure they understand that that money's not right around the corner, that it is a drawn-out process, and there needs to be some patience for those folks who are not EO eligible or who are EO eligible but decline the EO offer, all right? Now, as far as expected timelines and milestones go, here's what we're looking at. By the end of 2025, the settlement masters have said we want to have a global resolution process or matrix agreed to by the parties and in place. Again, seems overly optimistic from my perspective right now, but hopeful that can be achieved. Next year, 2026, that's when we're going to start to see Track 1 bellwether trials occurring in the Eastern District of North Carolina. And it's going to be the verdicts or settlements as a result of those trials that will likely help to inform the settlement masters regarding the global settlement values in their global framework or matrix, right? And then post-2026, if we can get this global process agreed to sometime over the next 12 months, we're going to be looking at claims processing, settlement offers, payouts following into 2027 and beyond, okay? Folks, we are not weeks or months away from Camp Lejeune being done. We are years away from Camp Lejeune being done. So, attorneys, if you represent claimants who are in poor health or have urgent medical needs and who qualify, the EO remains most likely the fastest route to money in their pocket, but they understand that it comes with certain trade-offs, and they need to understand what those trade-offs are. Accepting an EO offer is most likely the fastest way to get payment, but it's most likely going to also result in a lower settlement amount, both in terms of gross settlement proceeds and net settlement proceeds, all right? So, some final thoughts here to wrap up this November 2025 Camp Lejeune litigation update from the lien perspective. While the litigation continues to advance, it remains a large and complex process with many parts moving simultaneously. While parties should be encouraged by the optimistic goals of the settlement masters, claimant expectations need to be tempered. Okay, we are a long way from the finish line when it comes to this litigation. For the clients of Cattie Gonzalez, those folks who we are helping to address lien obligations, our core values of professionalism, empathy, advocacy, collaboration, and excellence remain front and center. We encourage claimants and their attorneys to stay informed, keep documentation up to date, and set realistic expectations about the timing of recovery. With respect to the liens that our clients are asking us to address on their behalf, we are as aggressive in representation to minimize potential lien repayments as our clients direct us to be. Our philosophy is not about cutting deals with lien holders for the sake of efficiencies. With our clients' direction and consent, we will exhaust all legal arguments and channels to minimize and zero out potential lien repayment obligations. This is the small part that Cattie Gonzalez is playing in this massive litigation, which affects hundreds of thousands of lives. If you're a claimant or an attorney and you'd like to discuss the status of your case from the lien perspective, where liens might fit in within your litigation timeline, or how best to address liens as part of the Camp Lejeune litigation, we're available to help. Visit www.camplejeuneLienResolution.com or www.cattielaw.com. All right? Email us at info@cattielaw.com. Call us at 844-546-3500. Or email me personally, jcattie, C-A-T-T-I-E, @cattielaw.com. We are here to help. We want to honor those that have given the ultimate for our country and get the best possible reductions and lien results anywhere in the country so that these individuals who gave so much can get the best possible result from the litigation with respect to the Camp Lejeune matter. Thanks.